Got a question on TikTok about does adding any and all unknown occupants to any type of like termination notices or even to the unlawful detainer complaint address any legal problems with unknown occupants. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, this does come up from time to time in practice, basically, because sometimes a landlord, you sign a lease with, tenant A and B, right? Husband and wife, that type deal, or whoever, right? And then eventually, other people might reside in the home, or, you might have people in there that, are just living there, but you don't know who they are. Okay. So, in our office and most landlord practices, yes, there's going to be an all unknown occupants listed on the notice. However, that provision is not going to save you necessarily if you actually know or have notice or should have notice of an actual person that's living there, particularly on curable notices like 3-day notices to pay rent, that type of deal. That's usually where it comes up, is because, for example, if a landlord accepts a payment from a third-party tenant, like a tenant, like tenant C, right? And they know they actually live there. Okay, tenant C needs to be listed on the notice as well too. They're in the eviction, our world, basically in the eviction process. Pretty much any like tenant or known occupant is entitled to notice, basically. So my practice and my train of thought is anyone that the landlord knows is that is actually living there on the lease, not on the lease, but you've accepted rent, or that they're living there, they're getting listed on the notice. Everyone's getting served. Okay, to avoid a potential argument in court about tenant not receiving notice. And one of the essential elements on particularly curable notices like non-payment of rent and stuff is proper service of the notice. You don't want to have to get an order from a judge saying, hey, landlord, you knew that tenant C lived there. He's paid you before. You didn't put him on the notice. That all occupants thing is not going to work because he's entitled to notice. Okay. Good deal. Okay. There are a lot of things like rules with like subtenants and, if a tenant is subletting a property, which kind of happens in the commercial context a lot. And, sometimes you don't have to serve them if they don't have a direct relationship to the landlord, that type of deal. We won't get into the weeds on that. My train of thought is better to name everyone than not, because you don't want to get called out in court that you didn't serve someone. It's less of an issue with incurable notices like 30, 60, 90-day notices, but still that argument can still apply, like, hey, especially if they're on the lease, especially if that they're living there, they can make that argument. Well, you never served me the notice, therefore you're not entitled to, evicting me. You can evict everyone else that got notice, but that tenant might be an issue. So it's better to serve everyone. Okay. In the next video, we'll talk about the unlawful detainer complaint, and we'll talk about what's called a prejudgment claim of possession to deal with true occupants that the landlord may not be aware about. Okay. Folks, if you have questions like these, like you're having a non-payment of rent situation, or you're issuing any type of termination notice, we're here to help out, to guide you through that process. If you're in the Northern California area and you need help dealing with this issue, feel free to reach out. We might be able to help out. Until next time, folks, I'll talk to you then. Thanks.